morning and welcome to an oral argument session of the 5th District Court of Appeal. My name is Rand Wallace. I'll be presiding over this case. I also have joining me on this panel from Seminole County, Judge Jim Edwards, and from Orange County, Judge Dan Traver. We have one case on the docket this morning, Widerman Malik et al. Versus CHS Settler of the JF Special Needs Trust et al. Mr. Shaneen, we have you as the appellant. Before we get started, I'm going to assume that you want 5 minutes of rebuttal unless you tell me otherwise.
5 minutes works great, Your Honor. Thank you.
Okay, great. And Mrs. Fernandez, welcome.
Thank you.
And I would just ask that everybody silence any noise-making devices they have so it doesn't interrupt the lawyers. And I guess the ultimate safety net is just keep your device on mute or your mic on mute when you're not speaking. And Mr. Shaneen, you may begin.
Thank you and good morning, Your Honors. May it please the court. My name is Nick Shaneen and I represent the appellants in this matter, the law firm of Widerman Malik and the independent law firm of Celebration Law. The case that's before Your Honors, it's not the first time it's been to this court. This matter has been to this court a couple of different times in a couple of different iterations. But this time it comes where both sides are going to argue to you that the law of the case has resolved the issue that's before you. So we're both going to approach with the same case law, but obviously from very different angles. And it is the appellant's assertion that if this court applies that law of the case and uses it to properly enforce this court's prior order, in addition to adhering to the procedural and substantive safeguards that are due a defendant in a FUFTA matter, then this court will necessarily reverse and remand to allow for those protections to inure and the proceedings to occur in their due course below.
Mr. Shaneen, we've got our courts entered a decision that basically says law of the case does not apply when something could have been decided on alternate grounds. You're not challenging that particular aspect of the doctrine, are you?
I am not, Your Honor. That we're going to take the law of the case doctrine on its face. The Florida Department versus Giuliano, Florida Supreme Court case of 2001 decision that both sides decided that the trial court was bound to follow the prior rulings of the appellate court. As long as
here's where I'm getting with that.
Sure.
Just in terms of some of the background in this voluminous record.
It is.
You've got the motion for disgorgement, which is filed on an appellate level, which you're claiming gives rise to the doctrine. That correct. Particular motion specifically demands in it that the 5th DCA conduct an evidentiary hearing. We kind of accept that as a given that we don't typically do that sort of thing, if ever. So there's one aspect of it.
Sure.
The response that was filed by your clients says, hey, these issues are completely outside the scope of this immediate appeal. So there's a second option. There's an unelaborated denial, which I think you're encouraging us to view as a denial with prejudice, even though it doesn't specifically say so. And then you've got the motion to quash that's filed 10 days later by your client in lower court, which now says, hey, this is law of the case. 17 days after that, you've got the actual argument, the evidentiary hearing, in which your clients then say, hey, that wasn't one of our issues on appeal. So knowing that we've got a situation where law of the case doesn't apply, where something could have been decided on alternate grounds, how can we not say, looking at the record, that that motion couldn't have been decided because the 5th DCA doesn't take evidence, or because the issues were outside the scope of the appeal, which is recognized by and argued successfully both by your clients twice?
Certainly, Your Honor. And the facts that you've laid out properly outline where we're at. The difficulty for all of the parties is that when this court enters an order, it means what it says. And if it wanted to deny it without prejudice, it certainly could have. If it wanted to elaborate with a single sentence saying denied because of a lack of an evidentiary hearing being proper for the court, this court certainly could have. But it is not proper, in our view, for the trial court, for one party or the other party to decide what the Fifth DCA said when the Fifth DCA says what it says and means what it means. Here, it is admittedly an unelaborated order, but it is a denial. Why that denial? Whether it was on the substantive arguments that were before the court, because those were certainly argued too, or the procedural arguments of, hey, this is premature. Any of those could have been the ruling of the court, but ultimately this court can and does apply its own rulings later when revisited with the law in the case argument to tell us what this court meant. And so when this court is as definitive, as pure as that order was, saying it's denied, it comes to the court as it comes. And this court is the only entity that can properly assess and tell the parties if this court meant something less than denied when it denied that motion for disgorgement. All of the facts were clearly before the court at the time, even though it certainly was an argument to be raised that, hey, an evidentiary issue, an evidentiary hearing would not, as you pointed out, Your Honor, be proper before an appellate court under most circumstances. There are,
if that motion had been granted, then wouldn't your clients have this outstanding argument that their due process rights weren't satisfied because, for example, the sanction would have been $100,000 higher? Whereas when we saw at the evidentiary hearing that for whatever reason, I think it was because it was omitted from the freeze order, $100,000 of the payments weren't levied as a sanction for violating the freeze order. So, wouldn't your clients have had this amazing argument that why is the Fifth DCA unilaterally coming down from its ivory tower and ruling on matters of evidence without calling witnesses?
Of course, Your Honor, to whom would we pose that argument to, that the Florida Supreme Court only takes
a properly raised motion for rehearing, I suspect. But still.
That again, we take the facts as they are, and we take this court's orders as they are. That we didn't invoke the discretion of this court and the jurisdiction of this court to request that disgorgement. It was, of course, the plaintiffs on the other side that did so. They did so loudly and with great sincerity and lots of case law and facts, and put it all before the court. And this court looked at what it looked at and said denied. And
Mr. Shaneen, why wouldn't the case of HFC versus Alexander and the concept of judicial estoppel bar you, since your client successfully raised the fact that the motion had no business being decided in the Fifth DCA, and you successfully raised that, and now you're trying to walk away from that? I don't understand.
Well, and Your Honor, of course, I respect greatly the HFC decision, and
we're both very familiar with it, I know.
So I don't question that at all. The problem here, Your Honor, is that when there's several arguments that are raised in for or against an issue, and the subsequent discussion, does not. Okay, I'm gonna rephrase here. That the answer to the question is that unlike in the HFC circumstance where there was a direct estoppel circumstance where it was this argument that was argued, it prevailed because that was in a court ruling, and then someone attempts to argue something on the opposite side of it. This is not that circumstance where had this court said.
Doesn't that bring us though back around to what Judge Travers started the discussion out with? That's the whole difference between a res judicata thing where it could have been or may have been argued and wasn't, versus here where we don't know that it was actually decided on the basis that you talk about. So
certainly, and of course, ultimately that comes back to this court, that this court does know what it means when it says what it says. And there are case law that this court has used to say, we see that the one side is argued that we didn't mean this. Let us explain that we did. So it's simply that this court is the arbiter. I don't claim to have any wisdom outside of what this court has provided, nor do I normally attempt to scry for such implied rulings. The ruling was the ruling. We sought the lower court to apply the ruling as it is. It is up to this court whether it wishes to do so or not. Of course, there are several alternate reasons why this court should still reverse, regardless of whether the law of the case doctrine makes it a very simple and quick decision. The longer version isn't much more complicated either. So those issues involve the fact that the bond was placed on was not funded until December 15, 2017. And the funds that were allegedly provided from the clients to their attorneys so they could properly be defended in court were provided before the bond had been secured and in place, and therefore before the injunction was effective. And there is much discussion in the briefs regarding validity versus enforcement. And here, the question is not whether it was proper for the lower court to decide to enter an injunction. This court has already ruled that it was, but this court also ruled in that same decision that it was a ministerial act that must be performed by the lower court to impose a bond. And I think the term ministerial may have been, yes, Judge Traver.
Sorry, I should know to unmute myself at this point in time.
All good.
Yeah, so let me ask you this in the form of a slightly different hypothetical, because I wrestled with this argument. So imagine that instead of talking about paying law firms, we're talking about not chopping down the proverbial 800-year-old oak tree. So there's a hearing, and the trial court says, I am enjoining you from chopping down the 800-year oak tree, and I'm going to condition that, unlike in this case, on a bond.
Sure.
You know, private environmental property, go down to the clerk's office and put the bond in place. And in the meantime, the unsuccessful lawyer runs out to his car, fires up his chainsaw, and cuts down the oak tree before the bond goes into place. Under those conditions, can the trial court sanction the lawyer with the chainsaw? The answer has to be yes, right?
I would agree, Your Honor, that there are clearly different circumstances in that hypothetical than here that would make that sanctionable conduct, whereas what occurred here, not so. And
there's
the
no
answer
bond.
is, well, and no bond was clearly, it was an erroneous problem that got created by the lower court the first time around by entering an injunction with no bond. And then when a bond was secured, it was well after the transactions that have led to this third matter. I would raise to this court the decision in Salas versus Alexander, where in that court said, because the appellee never posted the bond set by the trial court, there is no injunction in effect and no case or controversy for us to decide. So what we have here is until that bond exists and gets funded, there is no case or controversy. That what you're discussing.
Do you have any cases for that other than where the bond was specific, the injunction was specifically conditioned on the posting of a bond?
And that's the interesting part, Your Honor, that we only like to come to this court with new and different issues, and that is exactly what's occurred here.
Right. And you know, and I agree, it's tough for both sides, because on the one hand, you got 500 cases saying you have to honor an injunction unless the court lacked subject matter or personal jurisdiction, including a case in which my dear old dad was reversed. But on the other hand, you've got that it's really, what's an injunction without a bond? And, that's what we're going to hear from Ms. Fernandez, I guess, on what you do there. But as Judge Traver suggested, is anybody, much less a lawyer, as the Taylor versus Cersei Denny case suggests, is anybody free to disregard a court order without risking sanctions if there's jurisdiction?
And the answer is, of course, you're never free to disregard an effective court order.
No. There we go back to Taylor versus Cersei Denny and Health Club and all the rest of those. Even if the injunction is flawed, you still have to obey it until it's modified, withdrawn, or reversed on appeal. You have to obey it. And that's what the court here is saying. There was an order in place. Your clients obviously knew about this. There was no question of notice. And yet they chose to disregard and help other people disregard the order. And you're not saying that you can do that without facing sanctions, are you, as a lawyer?
And that's correct. But the sanctions can't be what the sanctions were in this case, to jump to the end of the line to require disgorgement of the entire amount of the controversy. That to do so obviated all of the procedural safeguards in Chapter 59. It disregarded all of the statutory guidelines and substantive guidelines in the FUFTA Act. And it also
didn't seem like anything about a very detailed trial court order had anything to do with any of those things. I mean, this is just I'm telling you not to send the money to somebody else, and you do.
That Your Honor, that the facts as they are peculiar to this case give rise to a circumstance where the client believed, or the lawyers believed, based upon the decisional case law, that this was not an effective injunction, and therefore they were appropriate to use these funds for that purpose. But the sanctions, if there's going to be sanctions for the penalty of violating something that has not yet become otherwise effective, those have to be sanctions that are narrowly tailored to address what the court appeared to be a breach, not a default. The other side wins, gets the entire disgorgement. That violates these concepts. I see that my time approaches the 5 minutes. I would like to reserve the time for rebuttal, and I thank this court for its time.
Ms. Fernandez, you may begin. And you're on mute. Hold on 1 second. You're on mute.
Happens to all of us.
There we go. Good morning, Your Honors, and may it please the court. As Mr. Shaneen was ending there, he was talking about the order needing to be a sanction order specifically tailored to address the wrong. That is exactly what Judge Alvaro's order was. It was as a result of an evidentiary hearing. It was the result of much thought and very specific and detailed. It is a sanctions order. It was not an adjudication on the Fraudulent Transfer Act claims. The order was very specific that what it was doing was sanctioning these lawyers for conspiring with their former client to deprive the plaintiff, my client, from monies she was otherwise entitled to through the preceding supplementary. It was sanctioning.
What in the record supports the trial court's determination that Celebration Law and Wiederman Malik need to be jointly and severally liable?
Your Honor, I believe that what the court was relying upon there is the fact that it found they were joint intentional tortfeasors. At the
law firms or the individual lawyers?
The lawyers as principals of the two law firms, of the individual law firms. Mr. Wiederman and Mr. Validity testified at the evidentiary hearing that it was basically the buck stops here. If there's money that was written to us, we took it, we cashed it, and they were the principals of their separate law firms at that point. Mr. Validity has now joined Wiederman Malik and is part of that firm. But
Ms. Fernandez, the joinder portion of that is because the court applied that based upon the relationship as it existed before the two law firms joined. Is that correct?
It is correct. It is correct, Your Honor. And
so would it be more akin to a co-counsel relationship between the two law firms? And that would be a reason why the joint and several liability is in place?
Yes, Your Honor. The facts were that Mr. Validity represented all of the defendants at the first initial hearing with Judge Kest on November of 2016. At the second hearing a week later, the Wiederman firm, Mr. Wiederman and several other lawyers from the firm had all joined in as co-counsel in representing the defendants, including Dr. Pendergraph and all the myriad corporations, Wilson Medical Management, which was the one that was paying the money at Pendergraph's direction to the lawyers. So not only are they
Isn't Celebration an independent law firm still, as Mr. Shaneen alluded to in his opening remarks there? I mean, it wasn't a merger of law firms. Mr. Ippolito joined the Wiederman firm, correct?
Correct.
All right. Now let me jump I'm going to change channels real quick on you here.
Okay.
What's an injunction without a bond? I mean,
good question, Your Honor. There are many cases, as everyone is familiar with, that say to have an injunction, it requires a bond. But what should have happened here is that these lawyers, these defendants, should have at the initial hearing said, Judge, we need a bond because this is an injunction. We need a bond. That was never raised with Judge Kest. And this court pointed that out in the very first appeal of the freeze orders, that in the lower court, you didn't mention anything about a bond, but because a bond is a ministerial matter that the trial court must do, we are affirming these freeze orders. That is what this court said. They affirmed the freeze orders and remanded it for imposition of the bond, which then was done. It does not, the right.
Typically, we don't want to hear about anything that wasn't raised in the trial court. So the fact that a bond is so instrumental to an injunction, you know, we said, okay, you didn't raise it, but that's all right. You got to have a bond if you're going to have an injunction. So again, my question is, what's an injunction without a bond? And I struggle with that. Most of the cases where it comes up, it seems that a bond was the injunction was specifically conditioned on the issuance of a bond, and the person seeking the injunction never paid the bond or paid it late, and then still tried to rely on the earlier date. Of course, every case has its wrinkles. The Williamson case, it was a customer list and they didn't even identify the right customers yet. So it had different wrinkles than this one. But I mean, again, you know, where are we with that in terms of the enforceability?
And Your Honor, the remedy that the appellants had was to raise that issue and or seek a stay of the injunction. That the remedy was not simply, we're not going to follow it because we think you're wrong. And we're not going to tell the trial court that we're not following it. And we're not going to tell the 5th DCA that we're not following it. We're just going to keep taking the money out of those frozen accounts because we just think the judge was wrong. If that was allowed to stand, our entire judicial system would evaporate. There would be no rule of law. They have never come forward with a case, and I don't think there is a case that says, you know what, if you don't think that the order was the right thing, you can just ignore it until it gets reversed in the years down the line. There's actually cases that say exactly the opposite. The Health Club case, which involved a injunction that ultimately was reversed. This one never has been. This one's been upheld now for going on 5 years. Said you can't just ignore the order of the court because you don't like what the court had to say. But that's what these attorneys have done. I mean, they've admitted that they've done it, that they determined and they advise their client that this order is no good, there's no valid injunction, and you can just keep on paying us out of those accounts to the tune of close to $300,000. But because of a glitch in the initial order, the recoupment amount was just under $200,000. And that just cannot.
In this appeal, was the actual amount of the sanction questioned?
No, it is not, Your Honor. No, it is not. Yes, there was an addition, and then the 2 final judgment amounts were, the amount was agreed to. So that's not an issue. But
I mean, not so much the mathematics of the amount, but in other words, saying 199,000 is just way too harsh a sanction. I mean, in the, what was it? The Taylor versus Cersei Denny, it was like $1 million or something like that. And that was found to be.
Exactly. And that found.
Sorry, I've got yard guys coming by.
No problem. No problem.
I'll mute.
And the Taylor case is a perfect example of exactly why this court should affirm this case. In that case, they told the attorneys, you don't just get to, I like the quote because it says, an injunction must be obeyed and until vacated or modified by the court awarding it or by a superior authority, or until the order of decree which granted it has been reversed on appeal. No matter how unreasonable and unjust the injunction may be in its terms, no matter how flagrantly the rules of equity practice have been violated by the court in ordering this issue. And the fact that it is lawyers, and this was from the Cersei Denny case, to begin with, we emphatically reconfirm the principle that every litigant, and especially a lawyer, must comply with an injunction, even those that the person believes in good faith to be entirely erroneous. This is undoubtedly even more true where the injunction has survived on appeal, as happened in this case. And as happened in this case, this order has survived not 1, but 2 appeals by these same appellants, first on behalf of their clients, now on behalf of themselves, they have argued time and time again before this court the exact same issues. That the bond issue was raised in the first appeal, where this court affirmed the freeze order. And then they raised it again when they tried in the lower court to dissolve the injunction and challenge the order on remand. And once again, this court per curiam affirmed both of those orders. It's ironic to me that they are raising law of the case when the clear law of the case is that these freeze orders were affirmed. They were affirmed with an opinion. There's no question about it. This court could have, reversed it, avoided it ab initio, but it affirmed the freeze orders. And knowing that, the appellants still continued to take money out of the frozen accounts throughout 2017. They knew of the affirmance and they went back to the trial court and tried to undo it again. And they were told by not just Judge Underwood, but Judge Meyer, this is the rule of the case. You took your appeal, you lost, move on, but just kept on and on. And the reason they were doing that, obviously, is because they were continuing to take the money out of the account, which they had to have known was wrong. And they weren't caught until after the fact. In the debrief, it just talks about how Mr. Validity testified that not only were they taking the money, they were instructing their staff to redact their firm's name from the checks so that when we got them in response to a request for productions, which were months and months and months overdue, we couldn't figure out who they were to. And so then they had to unredact it. So it's clear that they were doing their best to violate the order, to hide the fact that they were violating the order, and to recover money for it, to fill their own pockets. They raised these arguments of right to counsel, that right to counsel trumps the judge's power in entering an order. But the two cases they cite are very distinguishable. Number one, the civil case, Melton versus State, involved an attorney who was working pro bono in that case. The Lewis case, which is a criminal case, and of course is very different analysis, as the trial judge pointed out here in its order, presumably abided by the defendant there, presumably abided by the injunction until it was overturned on appeal. There is nothing in Lewis to suggest that the defendant intentionally violated the subject injunction, or that, having done so, was insulated from liability because of her violation was in furtherance of her Sixth Amendment rights. They had the right to hire the lawyer that they want, but they needed to use money other than the frozen accounts, and they did choose not to.
I have a very technical kind of question for you.
Yes, Your Honor.
In terms of the bond that was ultimately filed, my recollection of the timing is the freeze orders were entered in November and December of 2016.
Right.
Then in December of 2017, after the first appeal, the court entered the bond amount of $50,000, and that promptly thereafter, your clients filed the bond.
Correct.
My technical question is, bonds always have a condition. In other words, there's a purpose stated in the bond. And what was the purpose stated in the bond, if you know off the top of your head? And I'm going to ask Mr. Shaneen the same thing. I mean, typically it's if the injunction was wrongfully entered, then the bond is at risk. Otherwise, it's not. Or do you know what the condition is specifically?
And I'm remembering from memory, I believe it was to maintain the freeze orders in place. I remember writing that in the language when we were getting the bond, to maintain in place the freeze order that was, and we specifically said in the freeze order dates of the two orders of the trial court. So that's my understanding of why, to keep it in place, not to start a new bond. But that was what I recall, Your Honor. I come back to, again and again, just the court's inherent authority, because I think that is the most critical matter before this court, that attorneys, all litigants, but most certainly attorneys, cannot be permitted to, without repercussions, violate trial court orders, hide things not only from their adversaries, but from the court, and profit from it. There is no case law zero that says they're allowed to do that. And that is admittedly what they did. Admittedly, happened a year and a half too late because they had been doing it for a year and a half and the money was already gone. But they ultimately did admit that they knew about it. They knew that they were participants in the 2 appeals. They knew it had been affirmed, and they just decided they were going to continue to take the money. Let me speak for a moment about the court's initial questions about the law of the case argument by the appellees. As Judge Tarver pointed out, and I think Judge Edwards did as well, when that request for disgorgement was filed by us in the 2nd appeal, there had been no evidentiary hearing by the trial court. There had been no findings of fact. In fact, both of the motion was filed in both of the courts at that point. The appellants argued, wait a second, there's been no evidentiary findings. This is not an appropriate matter for the appellate court at this point. And admittedly now, in hindsight, they were right on that point. As the court pointed out, when it denied that, when the appellants tried to quash the order, the judge said that an appellate court is by definition exists primarily to correct error by a trial court, not to act as a fact finder. The determination of whether disgorgement is appropriate is necessarily a fact determination, must be determined in this court before review in an appellate court. We skipped a step, admittedly, back then, and the court, your honors, were right in denying it because procedurally it was improper at that point. It was not a finding on the merits. It could not have been a finding on the merits because there were no facts that were taken. There was no evidence that was heard. That's the function of the trial court. That's why it was sent back to the trial court. That's why we spent 2 days in June of 2018 getting to the evidence and the reasons that the disgorgement would be appropriate. So it can't be the law of the case. It's just as the Giuliano case talks about what is law of the case. It also talks about, and this is from the Giuliano decisions, where a previous appellate court has given no explanation for its decision, a subsequent appellate court is not bound by the law of the case unless a determination concerning the propriety of the trial court's order is necessarily inconsistent with every possible correct basis for the earlier ruling of the appellate court. We don't have to guess what the possible basis was. We know, and it was argued by the appellants to get it kicked back to the trial court then. Then once kicked back to the trial court, they want to say, wait a second, nope, the 50CA said it was denied, so now you can't argue it. They can't have it both ways. They can't say you can't get the trial, you can't be in the appellate court getting, and now you can't get back in the trial court because it's not the proper location. Clearly, the law of the case does not preclude the trial court from, after an appropriate evidentiary hearing and with specific detailed findings, ordering the disgorgements of the money that they found that these defendants and their lawyers took out of the frozen and joint account. It went through a very detailed analysis, and as Your Honor pointed out, there were some $100 or $1,000 or so that they still get to keep because the Center of Orlando for Women was not included with the freeze order. The Orlando Women's Center was, and then after the verdicts, Dr. Pendergraph went and fooled around with the letters and started new companies, and that company didn't get captured in the freeze order, so that's where the money started flowing through at some point to the lawyers. So it's not as though there was even any overreaching. This was specific findings of money that flowed through these enjoined accounts for over a year to the law firms with their full knowledge that it was wrong. And simply, that's really the basis of the judge's order in a nutshell, because it cannot be permitted for lawyers to just ignore court orders. If they do so, they're at their own peril. I think Mr. Wiederman said it best when he said, you know, maybe we did take a gamble. Yeah, they took a really big, in my opinion, unethical, inappropriate gamble, and they got caught. And this court should affirm the trial court's very thorough, reasoned opinion for sanctioning these lawyers for their conduct.
Mr. Shaneen.
Thank you, Your Honors. And first, let's go ahead and start right back with the law of the case doctrine, that it's not a matter of the appellee getting to decide, well, we argued it then for a bunch of different reasons, but we're going to pick this reason that we now admit was wrong and say that must have been the reason of the court. Just like the trial court wasn't correct to make its guess as to why this court ruled what it ruled. And when I'm saying this, I'm coming from this court's decision in Discount Sleep of Ocala versus City of Ocala, just rendered last year, which turned on a law of the case point. And this court cited Giuliano and the other citations that we've talked about. And then it talked about how the trial court justified avoiding the conclusion of this court by concluding that this court had ruled on an incomplete record. And then this court responded to essentially the trial court saying, that assessment is flawed. We did not rule on an incomplete record. We ruled for these specific reasons. This court gets to decide why this court makes a ruling. We don't get to decide. The trial court doesn't get to decide. Neither appellant nor appellee gets to decide why it is that this court ruled. When this court decided after all of the briefing, after all of the motions, that motion for disgorgement was denied, this court could have included lots of additional language if this court had wanted to. This court did not. Whatever this court decides.
Mr. Shaneen, would you address the joint and several liability issue, specifically Judge Wallace's question to opposing counsel about joint representation?
Certainly, and thank you, Your Honor, for that, because the answer is that the case law is crystal clear that we cannot essentially pierce the corporate veil unless we have circumstances where there is a subsidiary business entity and a primary business entity that controls the subsidiary, for which there's an attempt to conduct some sort of fraudulent conduct that would allow for the veil to be pierced and joint and several liability to attach. Merely being co-counsel in the joint defense of a case cannot give rise to the merger of two law firms. Here, the trial court didn't try to say that. What the trial court tried to say is that we have one attorney who was with Celebration Law, who left Celebration Law and joined Winderman Malik, and that's enough for me. I'm merging these two for purposes of this judgment. That's improper, Your Honor. And
do you agree with the appellees that if we agree with only that issue in your brief, that the appropriate recourse is just a remand to direct the trial judge to enter effectively an amended judgment?
Your Honor, I can't oppose that would be the appropriate remedy if that is what this court remands for. However, that's a very important point, that right now Celebration Law who was responsible for $17,000 and only $17,000 of these allegedly disgorged funds, currently has a judgment pending against it for $200,000, and that can't stand. So it's not a small point. It's not a ministerial point. It's a critical point for each of these law firms, but particularly for Celebration Law, that this error of law must be corrected. And
Mr. Shaneen, if I take your argument to its logical conclusion, then does that mean that Mr. Ippoliti, even though he was originally part of Celebration Law, then came over to the Wiederman firm, would he then be held joint and severally liable with separate and apart from the Wiederman firm for the total amount?
At no point, Your Honor, has the lower court or this court found that any individual attorney is to be sanctioned. This judgment is against the two law firms. And so the moving of individual attorneys really has no bearing on this case. It's an interesting sub-fact to be looked at. It helps us understand why the lower court might have decided to rule this way or got confused, but it at the end of the day cannot justify the imposition of joint and several liability. So, Your Honors, the joint and several liability is the reason this court must reverse. But the Judge Edwards asked the question, what is an injunction without a bond? And the Salas case and the other cases make it very clear that the answer is it's not even jurisdictional enough to proceed on a case with. It's so important that this court reversed, even though that wasn't an issue that had been squarely presented to this court. It is of fundamental importance.
I still have the same question in terms of the timing. I think I was right on the timing. Freeze orders in November and December of 2016, bond imposed 2017. It wasn't actually enforced in terms of you have to pay this money until 2020, correct?
But for whatever reason, the trial court, even though the arguments were all presented in 2018, the order from the trial court did not come out until 2020.
Right. So it was
let's blame COVID for that, perhaps.
Well, and that could be, but I'm just saying in terms of timing and enforcement, the bond is there to protect against an improperly entered injunction. Your client suffered no damages, your clients, plural, suffered no damages until they were ordered to pay. And by that time, the bond had been put in place and was therefore for the enforcement of covering any wrongful order as to money, it was already in place, wasn't it? I mean, I understand I understand they're being punished, if you will, not if you will, they are being punished. They're being sanctioned for what they did before the bond was in place, but the order was not actually enforced against them until after the bond was in place. Am I being overly simplistic there? And you can be nice when you say it, but
I would argue instead of being overly simplistic, you're being technical, such that it's obscuring the fundamental point, which was that these actions, there was no intentional wrongdoing. It was simply that these were accounts that were being paid in their normal course of business because the attorneys believed
that's not going to, that dog won't hunt. That dog won't hunt. These folks knew what the order was. And there's certainly, if this were a criminal case, there's certainly evidence of trying to cover it up, which is suggestive of guilty knowledge. So that doesn't help me too much there. But again, the whole issue of when the bond comes into play, it wasn't actually enforced. They weren't ordered to pay anything until after the bond was in place, even though they're being punished for earlier acts, earlier accepting of money. And that's why I said it's, as you pointed out, you like to bring novel issues to us, and that's one of them. So
I thank the court for listening to the novel issues and for spending the time that it takes to weed through them. Ultimately, the appellants respectfully request this court to recognize its own decision in 2018 as law of the case, or alternatively, the bond issue being the issue that ultimately requires reversal, or in the alternative of that joint and several liability cannot stand. For each of these reasons, we thank the court for its time and request reversal. Thank you, Your Honors.
Thank you, counsel. Very well argued case. And we will be adjourned at this point. Have a great day.
Thank you, Your Honor.
You too, Your Honors.